Good morning, ladies and gentlemen. I'm delighted to introduce the Radcliffe Talks Real Estate webinar, The Right to Rise, the Opportunities and Challenges of Airspace Development. This is a series of talks where a member of Radcliffe Chambers speaks to a property professional on something that's topical and interesting. And I'm delighted to say that I have Simon Kenneally, partner at Buckles, member of the Association of Rooftop and Airspace Development, ARAD, who describes himself, I believe, as a airspace development evangelist. Is that right, Simon?
That is correct, yeah.
Well, welcome. Thank you so much for agreeing to join me for our co-presentation of The Right to Rise, the Opportunities and Challenges of Airspace Development. The topics that we want to cover today in our hour are as follows: the ownership of airspace, freehold and leasehold, technical feasibility, planning law, PD rights, extent, limit, conditions and qualifications, the rights required if one is to engage in this activity, lender funder requirements, Landlord Tenant Act 1987, tenants' rights of first refusal, rights to light and party walls, fire safety and building regulations, and exit strategy, disposal of new units and service charges. We'll probably aim to speak for about 7 minutes, Simon, will we not, on each topic?
Pretty much.
And that will hopefully give a very much an overview and introduction to this specialist area of practice. Simon, what do you think is driving the increase in interest in this particular activity, airspace development, top development, from your perspective?
I think the permitted development rights that came in have opened up the possibility of airspace development mostly across the capital, but potentially across the country. And have reduced a significant lag and barrier into getting planning permission for airspace developments and building them. That is a significant driver. The amount of airspace developments that are being done now is massively increased because of that. And in addition to that, it is becoming more well known by traditional property developers, if you want to call them that.
Yes. Developers come in all shapes and sizes.
Exactly right. That these opportunities are becoming more widely known, and certainly what we see is a lot of inquiries as to how do we do this and what do we need to know, and that is merely just because of the widespread knowledge that is out there now about airspace developments, and people are seeing the opportunities. And I think the oft-quoted figure, there's a potential of 180,000 homes can be built on airspace across London. Practically, obviously, that's not going to be possible.
No.
But when you're talking about delivering homes and delivering airspace developments in units of anything up to a couple, up to a few hundred, then it does become a key part of the housing supply, and obviously, the government sees that as well.
Yes. And there is, in fact, and you're a member of it, there is an association, a group that's formed in this space, which is always an indication of the amount of interest and activity that an association forms.
Yeah, we do. The ARAD, the Association of Rooftop and Airspace Developers, were put together by 4 of the leading airspace developers in the industry, both to lobby for airspace development and also to set standards of quality of airspace development to prevent the potential for airspace development to get a bad name in communities and in the public. And they're a very important group. They're very good at what they do.
Excellent. Well, the housing shortage, the relaxation in the planning system, issues of affordability, which are forever with us, but perhaps also opening things up. There's even opportunities for environmental, social, those sorts of gains as well, possibly with new technologies and roofs that may need attention. I think that's probably maybe another factor perhaps in the whole increase in interest.
Yeah, certainly.
Good. Excellent. Well, let's look at ownership of airspace as the first logical step. So, common law legal principle, the owner of land owns everything up to the sky and down to the centre of the earth, heaven and hell in theological terms, derived from a civil law Latin maxim, which I won't quote and reveal how poor my Latin is. But coming more into the more modern era, we had the Bernstein and Skyways case in 1978, which had to grapple with, does in fact the freehold include an infinite column of airspace? Because by that time, of course, we've got manned flights, and today we've got drones. We won't need to go into the civil aviation restrictions, a bit higher up than the basement, not basements, than the roof that we're talking about. I think subsoil is a topic for another day. And he said this: it's how much land, how much airspace one owns, the practical best striking of the balance is by restricting the rights of the owner in the airspace above his land to such height as is reasonably necessary for the ordinary use and enjoyment of his land and the structures upon it, and declaring that above that height he has no greater right to the airspace than any other member of the public. That was in the context of finding that there wasn't a trespass by somebody flying over Lord Bernstein's land to take photographs. We then had the Boccardo Star Energy case in the Supreme Court in 2010. That was actually about subsoil because it was pipelines as far down as 2,800 feet. But again, the same concept was grappled with practically. How far down do these rights actually extend? And Boccardo upheld the reasoning in Bernstein and sought to apply it. Or they proved Skyview. We also need to think about the Crane Tower oversailing and the Anchor Brewhouse case in 1987. How do you see licenses? Do you see them quite regularly in that context for development?
You do. There's a couple of points about crane oversailing. Is you have adjoining properties over which your jib and boom may oversail.
Yes,
and also the land that is retained to the tenants.
Yes,
who may have car parking spaces, garages, that kind of thing.
Yes,
and also the land that is retained to the freeholder. So if you take a lease of a roof, you still don't have necessarily the right to oversail the retained land of the freeholder unless you actually put that have that right granted after the lease. So yeah, it is common due to the fact that the way airspace development is usually done is by modular units rather than traditional build. And also, when you're dealing with a crane, there is always a question of where do you put it?
Yes.
I don't know. Presumably, it's, if you can get a stopping up order and that kind of thing, that's probably more your area than mine.
Temporary road traffic regulation orders, absolutely.
Yeah.
Local authorities on board. So just need to bear in mind, of course, that injunctive relief could be granted if there were to be a trespass. So moving on, if we just talk about dealings, for example, with the freehold, important, of course, to recognise that a owner may carve out a horizontal division of land to sell, and that can be either above or below, but we're not interested in below the ground today. And it's section 2051(9) of the Law of Property Act 1925. Land includes land of any tenure, and mines and minerals, whether or not held apart from the surface, buildings or part of the buildings, open brackets, whether the division is horizontal, vertical, or made in any other way. Flying freeholds, of course, as we peer out of the window of Radcliffe Chambers today, we can almost see Wilder's the bookshop, which is an example of a flying freehold. And in the Sovmots case in 1979, in the then House of Lords, Lord Keith said it was an uncommon situation in England, but becoming more common for there to be a flying freehold. And he said this: it is a conception which gives rise to a very complicated situation regarding the mutual rights and obligations of the several owners. And would your experience echo sentiment.
Yeah, I mean, yes, it's very rare to come across flying freeholds, but inevitably when they do, yeah, certainly, particularly in rights of support, flying freeholds.
Yes.
Yeah, very much so. But I don't know how common they are, or whether. Do you think that it's more of a historical problem, or are they still being created today?
Absolutely, that's an important point. Interpretation of the conveyance, the parcels clause, to see if the presumption that the conveyance of the freehold of land includes the airspace is potentially a relevant issue. If we come to leasehold, which is perhaps more critical, the question is, does a lease of land with a building on it include the airspace? And that, of course, is a question of the interpretation or construction of the lease, which is a contract. And presumptions, have been a lot of court cases, of course, on this. The upshot is one has to ascertain the objective meaning of the language that the parties have used. I think it's safe to say if the lease demises the airspace above a building to a tenant, then the tenant could restrain any trespass into the airspace in the same way that a freehold occurred. If the lease is of the whole building, or a vertical division, or a horizontal division, of those three scenarios, I think the presumption of demise in A, the whole building, or B, a vertical division applies, whereas I think it's fair to say it's more problematic if you've got a horizontal division of a building. I don't know if that perhaps accords with your experience, Simon.
I think so. I mean, when we're talking about, and I'll move on to this in a bit more detail shortly, but obviously when we're dealing with airspace, it's often in residential.
Yes.
And the demise clause is important. But where you have, for example, balconies,
yes,
how much airspace somebody can have above a balcony or above a terrace. There was a case several years ago now where the courts followed the principles that only as required for your reasonable enjoyment.
Yes.
And when you are standing on a balcony, how much airspace you actually need is not too far above your head. So yeah, it is a consideration, certainly.
Yes.
Yeah.
Good. All right. So can I ask you about, having dealt with the ownership issue, the sort of technical feasibility and what the issues are that tend to arise in what, assuming we've sorted out the ownership issue, and it's possible from an ownership point of view to undertake a development in a roof or above a roof.
Yeah.
How when it comes to technical feasibility, how do you see that arise? Yeah,
there's a couple of points, and when we're dealing with airspace developments, we like people to come to us in the first instance to deal with the technical feasibility. There are two main issues. We don't have issues, we have challenges. There are two main challenges to be overcome. The first is the technical and structural suitability of the building, which needs to be, you need to settle fairly quickly, immediately, in fact, because if it's not going to hold a development, then there's absolutely no point in doing it. Or if it's going to require additional supports, how much is that going to cost?
Yes.
The legal feasibility and technical feasibility is, we're looking at it, it could be so wide as to be unlimited as to the number of things that could need to be considered. For initial feasibility, we look at the existing leases in the building to ensure that the tenants don't have rights over the roof, they don't own the roof. And we've had several instances where a developer will come to us and say, we've agreed heads of terms with this freeholder, only to discover, for example, that the whole building is leased to a management company. So, you've been negotiating with the wrong person. So we like to settle those things fairly quickly just to avoid time and cost.
Of course.
Other considerations, we've discussed cranes very briefly, but also you have access. How are you going to get to the roof? Are there any rights or reservations in the existing leases that would prevent you from doing so? And is it technically feasible to do so? Can you get a staircase up through the common parts and up through the roof? Can you extend the existing lease? There's utilities, which obviously we need to get the utilities to the roof, and we need to look at utilities clauses in the existing lease as well, to ensure that there are no potential legal preventions that would stop you from moving the utilities or extending the utilities. And then you've got questions of capacity of the utilities, and also, where they're situated, which can provide problems. Practically on the ground, there's a question about parking, which I'll ask you about in a second. But normally we have to have parking spaces, and we normally need to have a bin store.
Yes.
So will the estate be able to accommodate that?
Yes.
On small estates, it may be the case that you have a building and you have 20 car parking spaces, and there is absolutely nowhere to put a car parking space or a bin store, or extend the existing bin store. And then a particular question, just from a legal point of view, the existing leases, and I'm sure we've all come across this, is older leases tend not to define the demise particularly well at all. We've come across situations where tenants own the exterior structural walls, which causes a problem if you're planning on putting scaffolding against it.
Yes.
And obviously repair obligations and this kind of thing. We've come across situations where the tenants own the void above their flats, or just have been using it for storage without permission. All of these things need to be covered off before we can even say, okay, let's get down to the proper legal work on this.
Yes.
But just in respect to parking, it's something I always refer to somebody else. When it comes to obtaining planning and parking, is it the case that for every flat you would need a parking space?
Not necessarily. It depends on the standards and where the building is. So there's a big push towards development near where there's very good transport links. This is one of the reasons why near railway stations you see these bigger developments, more intense use, because there's a move to try and reduce car usage. And I mean, this is a technical sort of point, could arise in any context. There's been case law over whether by virtue of Section 106, you can restrict future tenants to not apply for a parking permit in a residential area. This was a Kenneally and Chelsea, or Westminster case, can't quite remember which now. The planning policies are generally reasonably flexible, and a lot does depend on public transport accessibility. Yes. I've just got one. Well, I didn't mention adverse possession, perhaps, but you mentioned tenants keeping things in the roof. Just by complete coincidence, I was on site yesterday, as it happens, where unfortunately some flats have been formed in the roof void without planning permission, and that's a whole different story, enforcement action, all sorts of things. But what occurred to me is, how often do you have situations where there's plant in the void, water tower, tanks, and this sort of thing that presumably you've then got to accommodate elsewhere if you're going to develop flats within that void? Can that be a practical problem?
It can be a practical problem, certainly. And obviously on roofs as well, you have plant rooms. And you can have all manner of things on roofs, television, aerials, serving the flats. And obviously much depends on the wording of the leases, whether they can be moved or not.
Absolutely.
And especially where we have services which are exclusively serving particular flats, whether they can be moved. About a year ago, we got fairly concerned about the Telecommunications Act and the code. The Telecommunications Code. Because obviously, if you've got a telecommunications lease on your roof, and we know telecommunications companies are pretty much protected by Mammon himself. And so, there was a suggestion that due to the way the valuation of roofs was being done, that a telecommunications company wouldn't have to pay value for putting a telecommunications mast on the roof, and would have the right to do so, because out of that valuation, the use as a telecommunications act mast was removed. So we will read that telecommunications companies for the 5G rollout will just barrel across London and start chucking them on every roof they could find. And there'll be a presumption in their favour that they're allowed to do so. That hasn't come to pass, but again, it is still a risk, and a telecommunications mast on the roof is a problem. Obviously, the rights and reservations that come out of that lease, the rights to maintain the mast, and also if you're going to sell flats, do they really want to live next to a telecommunications mast? It's unlikely from a commercial point of view that do so.
Not the most attractive, and there could be health issues or fear of health issues.
Yeah, absolutely right.
Yes, it's there's no shortcut apart from reading the lease. It's kind of going into the detail. Good. Well, let's turn to planning, permitted development rights article for, again, a very technical area of the law of town and country planning. I'll try and take this quite quickly. Of course, the backdrop is that planning permission is required for either operational development, building, engineering. You don't need to worry about mining in, on, over, under land, or the making of a material change in the use of a land or building.
Mm-hmm.
We don't need to worry about change of use. But because the definition of development in section 55 of the Act, the 1990 Act, is so comprehensive, it will capture so much that permitted development rights have always been with us. They've been expanded a lot recently, but it's important to appreciate, isn't it? Is it not, that it's actually not? It's a grant of planning permission that is achieved. That the permitted development right itself grants the consent. It's not that there is no planning permission required. It's not an activity, that's to say, constructing, relying on one of these PD rights, is not something that does not require planning permission. And this is quite an important distinction, and we'll touch upon the recent case which made this very clear, the CAB housing litigation, the Secretary of State for Levelling Up Communities and Housing in Broxbourne and one or two other local authorities. That was a decision in February of this year in the Administrative Court. So the Town and Country Planning General Permitted Development Act 2015 grants planning permission for lots of classes of development in Schedule 2. Part 1, and this is slightly confusing, which covers development within the curtilage of a dwelling house, includes a Class AA, which is the enlargement of the dwelling house by the construction of additional stories. And that's what the CAB litigation was all about. So that's, if you like, the family, the individual context, rather than the commercial context. The commercial context is the 2020, July, June, coming into effect in August, 3 statutory instruments which introduce Class ZA, Class A, Class AA, AB, AC, and AD within Part 20, just to make, so we've now got 2 classes, AA, but within separate parts. But those are the more commercial ones. So, for example, Class AB is new dwelling houses on a terrace building in commercial or mixed use, and the possibility of development on flats is also given by the permitted development rights. So in essence, what happened, so just to make this clearer, so Class A is in these terms: permission is granted for the construction of up to 2 additional stories of new dwelling houses immediately above the highest story of a detached purpose-built block of flats. So that's the one that I think the focus is probably on. But the essence of the CAB case was that prior approval, so there's a prior approval process which is quite complicated, held that, or led to local authorities refusing to grant prior approval for these permitted development rights for these individual dwellings to build above. Each was appealed to a planning inspector, which is normal, where someone's disappointed by a decision. Each was refused, and there was a challenge to the lawfulness of the planning inspector's decision on the basis that planning inspectors had gone beyond what they were allowed to take into account. The answer was that they hadn't. So Mr. Justice Holgate said, effectively that an application to a local planning authority for prior approval under AA, because it was AA that was dealt with, but these principles apply to all PD rights because they're all formed in a similar way. The scale of development can be controlled within the ambit of one of the paragraphs. Impact on amenity not limited to overlooking loss of privacy or loss of light, but is broader. Adjoining premises is not limited to contiguous, but includes neighbouring. External appearance is not limited to principal elevations or side elevations fronting the highway. AA includes external appearance of dwelling house. External appearance is not limited to subject property, includes impact on neighbouring premises and localities. So the takeaway message is that even if you come within the conditions, limitations of the definition of the permitted development rights, as part of the prior approval process, there are still a broad scope and range for a local planning authority to not grant prior approval.
From your experience, how do you think local authorities will interpret and use that range going forward?
That's a good question. It's difficult to say because local planning authorities are so busy and they've got so much work, and the planning system is forever being tweaked and changed. And of course, if they don't take decisions within a set period, that can crystallise the ability to use a right. So they're up against timescale issues as well. I think it would probably depend on how. My own mantra is local planning authorities don't go looking for trouble, but if people object as part of the consultation process, then they're likely to look at it quite closely. And so you're bringing in, I mean, some people say planning permission light is a prior approval process. To some extent that's true, but there's still an awful lot of hurdles to get over. And of course, there are bear traps. So, for example, as you will know, permitted development rights can be removed by conditions attached to a planning permission, by a Section 106 planning obligation that came into being as part of the planning permission to grant the development in the first place. It only applies for lawful development. And then, of course, Article 4 directions and Kensington, Chelsea, Maitland, on a regular basis in lots of areas to restrict or take away permitted development rights, particularly change of use rights, but that's another story. So it's a very technical area, and it needs just the length of the statutory instruments themselves, 4 pages to describe one of these rights, the limits, the conditions, what isn't permitted, etc. It's a cold towel over one's head with the drawings to really see. I'm afraid there is no substitute for looking at the detail. Okay, lender and funder requirements. How does that work in practice in your experience, Simon?
Yeah, I mean, fairly briefly, because obviously all funders and lenders have their own requirements, and you can structure these deals in a number of ways.
Yes.
But essentially, the security is usually the lease of the 999 lease for roof with planning permission,
right,
for that lease to give the requisite development rights, and obviously, for it to be certified that that development can be carried out from a legal point of view, practical point of view. The only real nuance, and most lawyers will already have come across this anyway, is having step-in rights included in the development lease that will give the lender the right to assign the lease should the tenant go bust or substantial breach of the lease that causes termination.
Right.
The different period, the only nuance to that really is the different periods that different lenders require, and they can go up to 180 days now for the period within which a lender can step in and assign. The issue with step-in periods is obviously you are building, and the issue with airspace development in general is you are building on a building in which people are living already.
Yes.
So where you have freeholder who just wants to make a few points from the roof, a roof. That's not, that's generally not a problem as to what the step-in period is. Or you're dealing with management companies or more conscientious freeholders who want to keep their tenants happy, then you tend to find there can be some disagreements around what the step-in period should be, largely because people don't want an unfinished development on their roof. Now, because people tend to catastrophize this kind of thing, because obviously they've got a large infrastructure project going on above their heads. What they see is we will not have a roof on our building and everyone's going to get wet and everything's going to be ruined. It's almost certainly not going to be the case. That's almost certainly going to be covered off in the first weeks of a development. But still, people don't want unfinished developments on their roofs. They want certainty that it is going to get done and when it's going to get done. So if you're saying to a tenant, if you're saying to a freeholder or a management company who owns the freehold and to their tenants, we're going to need half a year in order to exercise this step-in period, then they are likely to disagree with it. So that becomes a point of contention. Beyond that, that is pretty much the limit of the lender and funder requirements beyond what are their normal terms. The market itself is still slightly naive in respect of the funding of airspace development. There are packages out there for airspace developers and funders who are becoming more aware of it. But certainly, I talk to funders on a fairly regular basis about whether they understand it and whether they fund it, and most of them still don't. But then there is the kernel of but we would like to. We just need to understand what it is. So I think it is a learning process for a lot of funders as to what the opportunity actually is. And they do have security there. A roof with planning permission with an airspace lease is worth, it is good security, and it is understanding that principle, which is the main hurdle to overcome.
And did you say 9 leases?
I mean, ideally, but
as good as a freehold. I wonder if you've come across the scenario, because again, it is something that I have experience of, where there's a big market in the sale of freehold reversions, and depending on whether leases are granted, the ground rents may be minimal or not a lot, or whatever the position may be. But where you've got reasonable size blocks of flats, and the possibility of putting up to 2 extra stories on more than one block, several blocks in a development in a nice part of London. That's considerable GDV. Very considerable GDV. Potentially there to add these new units.
You're absolutely right.
So I suppose that those sorts of people don't necessarily need funding, but then the opposition to what they wish to do may come from the current tenants, and you've already expressed some of the issues that those that are already there have about the idea of more flats going above their heads, as it were.
Yes, absolutely right. The uncertainty that creates. And certainly ground rent investment companies are very much seeing the potential of this now, and there's a big move in that sector in order to realise the value of them. It would be unlikely that a company like that would carry out a development themselves, just due to the amount of risk that's involved in doing so. We tend to look at it more from the developer side as to what their funding requirements are. Whether a ground rent company, for example, would have the capital in order to build on their own roof, I don't know. They certainly wouldn't have the expertise to do it, but they can pay, they can enter into development agreements in order to get that done. But you're absolutely right. The value of those roofs, it can possibly be very, very substantial. And it really can. It is very, very good security.
Well, I suppose with some developments, one sees the penthouse flat is the premier element within. You're adding potentially penthouses on top of the pound signs start to go before one's eyes, as it were.
Absolutely right. I mean, that's perfectly fine. You have the penthouse flat right until someone puts another penthouse flat.
And then the roof terraces you as well. Good. And of course, we just touched upon ESG, and there's the possibility of greening the roof and that sort of thing as well, which is interesting. We're obviously not going to get into embedded carbon or that level of sort of technicality, but if we turn briefly to the Landlord Tenant Act 1987, tenants' right of first refusal, I think it's fair to say this has been described by several judges as the worst piece of legislation they've ever had to try and interpret. It was rushed through before a general election, apparently, following a report by Ted Newgee. That's a long time ago now, the mid-80s, that report. So I think that the as we've discussed, it's perhaps now common practice for landlords to grant leases of airspace. And then the question is whether that's within the roof void or above the roof of a building. Now, that is very likely to be a relevant disposal within the meaning of the 1987 Act, isn't it, I think?
Yeah, almost.
Yeah, and there was the Dartmouth court case, Mr. Justice Warren, in 2008 now, gosh, what does the time go? And of course, there's 3 conditions to trigger consist of the whole or part of the building, the disposals are part of, contain 2 or more flats held by qualifying tenants. Number of flats held by qualifying tenants must exceed 50% of the total number of flats. So fairly easy thresholds, apply quite a lot, trigger the relevant disposal issue. Can be a lot of tactics in the timing of these sorts of things. How do you see that in practice, man?
Yeah, it's a difficult one for developers because obviously there's a sunk cost risk. So just to lay out for anyone who might not know, which I assume is very few people, that you have to serve a notice on the tenant giving them the right of first refusal.
Yes.
That has to be at the price at which you're selling the roof or on substantially similar conditions to which you are selling it. So if you're entering into a joint venture, then you have to offer the tenants to enter into the joint venture in the shoes of the developer. That then triggers a 2-month notice period during which time or before which you cannot exchange contracts for a disposal. So during that period, there's a question for developers as to whether they crack on and get their due diligence done and get their planning application in and incur those costs on the basis that the tenants won't exercise that.
I was going to say, presumably there must be a lot of cases where tenants will go, oh my goodness, joint ventures and all this sort of thing, I don't want to go near it.
Precisely,
But the statute gives them, so
Yeah, absolutely right. We do see various attempts at Section 5 notices to make them as unpalatable as possible, including
within the spirit and intent of the Act.
A couple that we've seen where the tenants are offered an option agreement and the purchaser under the option agreement to be called upon at any time during the option period to pay 50% of the consideration.
Oh my goodness!
Which is obviously going to put off any tenant. I'm assuming, and I may be speaking out of turn here, that it was never intended that the developer purchaser would have to pay that consideration, or it would be called upon. But obviously, as soon as the tenants will have exercised their right, then it would have been called upon. So there's some shenanigans that go on in this kind of thing. From our point of view, when we're serving Section 5 notices on tenants, we do make them as unpalatable as possible, but we make them very straightforward. This is what the deal is. You can have it or you don't. There's no shenanigans that we undertake. But you're absolutely right. So there's several factors as to whether the tenants may take up the Section 5. Largely, there's a balance to be struck between the size of the building. So a lot of tenants are more likely to be able to afford to pay the premium for the roof, but they are less likely to be able to organise themselves in order to get to the 50% threshold to do so. Smaller buildings are less likely to be able to fulfil, to get the money together in order to purchase the roof, but they are more likely to be organised to do so. So there's a balancing act to be struck. For a developer, as I say, if you do crack on with your due diligence and your planning application, would you sit on your hands and wait to see what happens at the end of that process? And that rather depends on how confident the developer is in whether the tenants will take up or not take up the notices, what their cash flow position is going to be, and what their appetite is for the risk and the costs of doing so. And we see it all. We see developers saying at the end of this 2-month period, I want to be in a position to exchange, and we see developers saying we'll wait for 2 months and we'll see what happens.
Yeah,
and it rather depends on what the risk profile of the developer.
got understood.
Yeah,
Interesting.
and to mitigate the position of seller, landlord, freeholder walking away from the deal, you can enter into a exclusivity agreement because that's not a binding contract for sale. And so you can bind the seller in for 2 or 3 months to say, you will not market or sell to somebody else during that period. And then at the end of that period, obviously, the developer has the security that at least the freeholder has to pay during that.
Yes.
So there is that to mitigate it.
Yes.
Yeah.
I mean, it's a tangential point, but of course, the 1993 Act bringing rights to tenants into closer to the current situation, present as it were,
Yes.
set collective enfranchisement claims. How frequently do you come across that?
It's infrequent. It's only really used by tenants who have either discovered there is going to be an Airspace development and are very unhappy about the fact. So it is a risk to property developers, to Airspace developers, merely because if you get enfranchising tenants, then they will take the building. And after the Queen's Court case, which decided that the roof formed part of the common parts, and as part of an enfranchisement, the enfranchising tenant should be able to take the Airspace lease, which had already been completed, with the freehold.
Yeah.
Then obviously there is going to be a risk there. Now, mitigating that risk, there are a couple of points. One is that as the value of the freehold and the Airspace lease, if you've got one, will be increased if you manage to get your planning permission over the line before the Section 13 notices are served. So you can increase the value, mitigate the potential risk of the losses that you may suffer on that. Would likely make a profit even. The other point is, in the Queen's Court case, the court did say that the position may be different where a development has already started, because obviously then is the roof then part of the common parts if it has a property development going on it. It's likely to be so. So there is, if you get cracking on, get your planning permission in place and get developing that property, then the risk of enfranchisement falls away largely. But it is a risk. It is a risk, but I don't think it's a huge risk, just because, again, the amount of money and the amount of organisation that's required would likely put off most tenants if they cared about the Airspace development at all. They have to be very motivated.
Interesting. Interesting. So, as a defence strategy, it can be deployed. I mean, I've got another situation where angel investor came in on a block for a lot of the tenants. The hope value, marriage value is the actual price that was determined at the tribunal. And then what's being said is that, in fact, this isn't really to do with the roof. It's more that the common parts, the extra bits that were added, are very valuable. And that the angel investor is somehow now entitled or will be making more money than some of the other occupying tenants under long leaseholders within that particular block feel is right and appropriate. But that's a different problem. I don't know, do you have difficulties with angel investors at all, or is that? No,
I've only ever acted on one where we acted for the tenants in that case. So it is a complicated thing for angel investors to pull off. Certainly. And there are lots of considerations. I think the only query for a property developer who is going through that process, if they are supporting and funding enfranchising tenants, is in the participation agreement that they enter into. They have to be identified as funding the development or funding the purchase. And so if a developer wanted to keep that under wraps, they will not have the opportunity to do so within whatever the timescale the participation agreement has to be created then to do so. So that's the only real query. Obviously, it is going to be a complicated thing to fund an enfranchisement and then put a contractual mechanism in place whereby you trigger the right to take a lease of a roof dependent upon the successful enfranchisement, which you are also financing.
Yes, it starts to get complicated.
Exactly right.
Put the wings of the angel investor.
It's uncommon. It's very uncommon.
Interesting. Good, thank you. So turning to rights to light and party walls briefly. So as is well known, I think a right to light is an easement. So it can be created like any other express grant, implied grant, prescription, whatever it is, if it's more than 20 years unobstructed use of the window. You just remember it's also skylights as well, it's apertures, but there is no automatic right to light. So the design of the existing building and the design of the proposed new stories, they must be critical, must they not, for consideration of whether or not what is proposed would potentially infringe and lead to an actionable ability to stop a development on the basis of infringement of rights to light. For example, the Dorrington Belgravia roof space case. How do you see that in practice, the rights to light issues?
In practice, mostly referring to rights to light. Yes. It's a tricky one. A lot of developers, especially if they are not used to building high buildings or on top of buildings, assume that daylight sunlight is the same as right to light. And if they've got 3 daylight sunlight, then that
from the local planning perspective,
and you will know what the conditions, the differences are better than I ever will. But apart from that, it is a question of have a rights to light survey done. And designs do get modified in order to account for that and setting the buildings back and whatnot. And as we briefly mentioned earlier, where tenants have roof terraces, and you mentioned skylights, to ensure that they're also not affected. But beyond that, it is very much a question of when you're talking about third parties, have a rights to light survey done, see if you're likely to suffer a claim if you build this, and then take the appropriate action at that stage. A question that
insurance
you can you can get indemnity insurance against rights to light claims, which can be fairly pricey. So the development's got to be worth it. And obviously I think you can serve rights for light notices. I'm not entirely clear on what the timescales in advance that they have to be done or where they are served, because that's a question for litigators rather than humble property lawyers. But that is also an option as well. A question I came across the other day, if you have a tenant who has had reserved out of their lease in favour of the landlord rights for life, and then a developer of a piece of adjoining land which the landlord doesn't own then builds on that land, affecting the tenant's rights for light, can the developer then rely upon the reservation of the rights for light in favour of the landlord, or does that reservation only apply to the landlord's property itself rather than the entire world? Because I'm assuming at the time something like that was granted, it could have only been intended that the landlord wanted to reserve the right to build on their own adjoining property rather than anything else.
Absolutely, as a matter of principle, I think that must be right.
I assume that's correct.
Interesting scenario. I haven't come across that sort of thing. That's fun. I mean, just to hopefully it's a helpful point. I always find it's useful to divide into public law, which is town and country planning, because there is an overlap, because as you've said, there are planning standards in relation to daylight and sunlight and amenity and overlooking, and those featured in the litigation we touched upon in the prior approval process. So that's a matter of public law, town and country planning. And then, of course, there's private law, real property law, landlord and tenant law, nuisance, trespass, etc., etc. So there is sometimes an overlap, but conceptually, I think it is useful to keep them as separate concepts. So turning to party walls, the Party Wall, etc., 1996. if proposed development involves work to a party structure, that's section 20, a party wall notice must be served on the relevant adjoining owner and a party wall agreement entered into. Party structure is defined as also a floor partition or other structure separating buildings or parts of buildings approached solely by separate staircases or separate entrances. So I think important to appreciate that the roof, the floor, the horizontal plane is very likely to be, potentially can be, a party structure. It's not just about walls, although the walls may be, depending on the nature of the development, relevant. How often, I mean, that legislation's been off the statute putting out for, again, over 25 years. Where does the time go? How do you see that in practice, the Party Wall Act?
Yeah, I mean, barely at all, because I know almost nothing about it. I would always advise a client to take the advice of party wall surveyor.
Yes.
I think there's a question as to which walls in a building may be party. That if you have a demise to a tenant, which is an interior demise, then presumably, although I may be wrong, the interior walls would not then be party if they are taking the load of, for example, a airspace development, because they're not structural walls. So I think there's a question for developers as to what walls are actually taking the weight of that development, and what walls will then be party, and whether they then also fall in a tenant's demise, which means that the tenant may be may have a party wall award due to them, or whatever their other remedies may be. And I'm not entirely sure what they might be. You may know that better than I do.
I think again, it's an area a bit like rights to light. I mean, there was a recent property litigation associated with a joint event with the Property Bar Association, where one of the topics and talks was on the world of rights to light, and the technology is changing in the sense that the Percy Waldron test found in that was formulated 100 years ago now. It was in the 1920s. You measure has there been infringement? You measure the amount of direct sky which will reach a hypothetical table 2 feet 9 inches high in the room behind the aperture, and if, despite the obstruction, 50% of the room's area receives 1 lumen of light at such table, that equals adequately lit. I mean, the world has moved on, and there's all these technological ways of looking at buildings and structures and intergeneration, etc., etc.
That's pleasingly accurate, though, isn't
Yes.
it?
People like to rely on the familiarity of what's been there in the past, as it were. But in the same way that there's a specialist cadre of rights to light surveyors, it's the same with the party wall world, is it not?
Yeah.
You've got there's been Pyramus Club and these surveyors that specialise in, sometimes I think in both topics or just in party walls, and so there's a cadre of specialist surveyors out there dealing with the work involved in the negotiation of the agreement of an award if it's necessary. So I think good advice that sort of expertise should be brought to bear where there's rooftop development contemplated. Now, turning to a topic, very important and topical topic, fire safety and building regulations. How important is that in practice?
It's becoming increasingly important, and is causing a lot of confusion in the sector at the minute. So the building regs require that buildings over 11 metres, new buildings over 11 metres, require retrofitting. Require fitting with fire safety equipment, fire measures taking, etc. There are 2 questions that surround that. Is one, whether building additional building that's on top of a building that is already over 11 metres
Right.
or takes that building over 11 metres would then trigger that requirement. The assumption is that it will. And then obviously fire safety equipment, fire doors, that kind of thing needs to be put into the common parts of the lease. So there's a cost question there, because you may be retrofitting a massive building, with very expensive equipment. The second question around that is, would that then trigger a requirement to put sprinkler systems in flats themselves? And that then is, I mean, obviously there's a cost implication there as well. Yes. But also whether the requisite rights are reserved out of the tenant's leases in order to do that. And obviously you then need to have the rights in the airspace lease in order to do it. As part of standard these days, I also include an indemnity from the freeholder if they should fail to obtain that access, because obviously we can't sell a development if we don't have the requisite rights to install sprinkler systems in a flat, for example, if that's going to be the case. There's a lot of confusion around it. The words from ARAD, the Association of Rooftop and Airspace Development, is, you know, there are ongoing conversations with the London Fire Brigade and with local authorities, neither of whom have a grasp on exactly what's going to be required or is required. And they both refer to each other. So it's a difficult thing to actually nail down. Now, the best advice for clients at the minute is obviously protect your legal position as far as possible in terms of, you know, the potential that you may not be able to sell these flats or do the development in the first place, but also have a fire safety surveyor come to an opinion that you can also rely on. And if they say to you, you don't need to put sprinkler systems in flats in order to satisfy the fire safety regs, then, you know, at least you've got that to hang on, and you've got somebody else's indemnity insurance policy that you can rely on if it turns out that they're wrong. So that's the best practice at the minute. Clarification should be coming fairly soon, I suspect. But again, it's a bit up in the air at the minute, and it's ironic that we got, you know, fire safety is clearly very important, but it's ironic that we got the permitted development rights and also the fire safety both pretty much came out at the same time. And I think the ministers in charge of those both respective elements both actually sit in the same office. So
joined up government.
Yeah, exactly. So you got this massively conflicting position where the government wants flats to be built, but also wants it hasn't given accurate fire safety, although apparently it does need to be done. So yeah, it's something to be resolved. I don't know if you've come across it at all in terms of planning, whether it has to be accounted for.
Only not so much in airspace development, but certainly in bigger development. There was a quite high profile case recently where the criticisms over the fire safety inadequacy caused the developer to pull the application and reworking it basically because it wasn't up to what was required from the authority's perspective. And of course, from the reputational damage issue is quite high of something as sensitive as fire safety.
Absolutely. And I think as airspace developers as well, you want to keep the tenants happy. And you want to be able to say to them, we are ensuring that you are going to be safe, and we are complying with all the relevant laws, as well as all the other things you can do to make tenants happier. So from a reputation point of view, it's important that it's addressed correctly as well.
But I mean, that's a different sector in a way, the big towers, I think, because when you look around London at the number of blocks of 3 or 4 stories mixed use with lots and lots of potential for development of additional, so you can certainly see the thinking behind that and the encouragement from the planning system, National Planning Policy Framework, as Guidance has been advocating it for a long while. Just turning to exit strategy, because obviously the units are built to be disposed of in some way, shape or form at the end of it all. How does that generally work in your experience?
It's a fairly straightforward process. Obviously, you plan for your exit strategy while you are taking your airspace development lease. The way our super special lease works, which I won't divulge, sets this out very, very
Right.
specifically. But essentially, you need to be in a position whereby you are going to surrender your existing lease or dispose of it in some way, and then to be able to sell the flats. There's normally a requirement that the new flats are leased in substantially similar terms or identical terms if the building is new to the existing flats.
Yes.
Makes sense. If it's older, then you may want to try updating those leases a little bit. But so you sell the units and then hopefully surrender your airspace lease if you've had the forethought to put that in to your airspace lease.
Yes.
Back to the freeholder, and then the entire building is managed by the freeholder, whomever that may be.
Right.
And so that's generally the way it's done. Disposal is just like any other flat disposal. It's a grant of a residential lease and interior demise. So that's fairly straightforward. In terms of service charges, and as we've chatted about briefly, there is a question as to whether, if the service charge is split out into exact proportions, whether you can then lawfully then add more flats and have them just in the proportions. Yeah. It's a tricky one. It's in a service charge scheme. It should not be an issue. If you wanted to go down a belts and braces route, you would have a new service charge scheme. That would then separate out the new development. So you'd have, an existing service charge and a new service charge, and then deal with it that way and make sure they dovetail correctly.
Yes.
So it is a consideration you need to think about. If you're talking an airspace development takes 18 to 36 months,
yes,
then you need to be thinking about this right at the start rather than halfway through.
Absolutely.
Because you need to understand what those leases are going to look like. That you're selling, right at the start, you need to have that in your mind.
Yeah.
So it's an important consideration, certainly.
Lovely, great. Well, I've heard the clock strike 12, Simon. So thank you so much for joining me.
Thank you for having me
on this Radcliffe Talks Real Estate webinar. But the right to rise, the opportunities and challenges of airspace development. We hope that's given people food for thought.
Yeah. Thank you for joining.
Thank you so much,
Thank you for having me.
Welcome.
Thank you.